Secured transactions is the topic we're going to find in this section. People and businesses enter into contracts for the sale of goods, which we know from previous topics that in a lot of cases credit is extended to individuals who can't afford the goods outright. But creditors just don't do that on a promise. An oral promise to pay back the debt doesn't guarantee or assure the creditor otherwise. Plus, it's also hard to prove. But even in the case of a writing or a written agreement, does that even work? Consider creditor bank loaned me $10,000 to buy a car, and I sign a contract that says I promise to pay it back within 3 years plus interest. Does that give the bank any assurances that I'm going to pay it? Well, they may say, hey, look, she has good credit based on her credit report, and she has a history of paying on time to her creditors, but is that enough to assure the creditor will get paid back? What if I lose my job? Or I get hurt and I can't work, so therefore I can't pay my bills? In any of these situations, the creditor is stuck holding the note or the written agreement in hopes to getting paid. Of course, they could sue, right? They could sue for breach of contract. But what happens if the person, in this instance, me, is insolvent? I don't have anything. As they say, you can't get blood from a stone. So the creditor goes to court to sue, and they pay court fees and attorney's fees just to get a piece of paper from a court that says judgment. Judgment, money owed with interest. That's what they get. But can they get the money from me? I might file for bankruptcy, which we're going to talk about. The creditor then invested more time and more money in the debt collection process. It's just an ongoing, costly thing to do. My point is, there's no security in the situation that I just discussed. Creditors want security for their loan. Real security for creditors comes in two forms. The two forms of security for creditors come in the form of an agreement with the debtor, and there's three components to that we'll discuss, and by operation of law. So the first of the three agreements is the most popular one, secured transaction, which is any transaction in which the payment of a debt is guaranteed by personal property. For example, I obtain financing to purchase a car, and the bank is going to hold a security in the car. The second form by agreement, we either call a suretyship or a guarantee. We'll go through those in more detail, what each one of those are. But they involve the willingness of somebody else, a third party, to pay if the primarily obligated party does not pay. Think of a cosigner on a loan. And the third type of security by agreement is mortgages. This is the agreement giving a lender an interest in or lien on a borrower's real property as security for the debt. Mortgages are discussed in another section. And then we have secured interests obtained by operation of law. A security obtained through operation of law is called a lien, which is an encumbrance upon property. It could be real property or personal property to secure a payment. For example, a contractor who is contracted to put a new roof on a home and a homeowner does not pay after completion, the contractor can place a lien on that real property. A court judgment is a monetary award from a court that converts to a lien after a period of time for collection. So that creditor that I discussed a little while ago who has to go to court and sue, and in the end they'll get a court judgment that says I owe $10,000 plus whatever the interest total was, and maybe they'll throw in attorney's fees and costs to go to court, and that will be presented on a piece of paper called a court judgment. It will indicate that I have so many days to pay. It's usually 30. And if I don't, it converts to a lien to which could follow me. There'll be steps to take to attach it to any real property I own or any bank accounts, but we'll get into that a little further in this section. There are 5 components of secured transactions that we're going to discuss. We're going to talk about the nature of the property subject to the secured interest, how a secured interest is created, perfecting that secured interest against other claims that might be made against that property, priorities among creditors, and then finally we'll talk about the rights of the creditors upon default by the debtor.